Good morning, members of tribunal and fellow parties. My name is Syed Ziaullah Shah and I appear as counsel for the claimant Jordi Construction in accordance with Article 18.1 of the LCIA rules. I will begin with a statement that my client recently have been aware of some evidences that lead to conclusion that Frederick Manson, presiding arbitrator, cannot work as a principal arbitrator. Hence, my client challenges to arbitrator's appointment pursuant to Article 10.3 of LCIA Rules 2014. Based on Article 10.1, justifiable doubt as to arbitrator independence and impartiality, and Article 10.2 acts in deliberate violation of the arbitration agreement, does not conduct or participate in the arbitration with reasonable efficiency, diligence, and industry. To summarize the matters of this arbitration proceedings, Jordi Construction signed a contract with Tower Limited on 7th of January with a very tight schedule for delivery. The contract contains a dispute resolution and arbitration clause. And due to deteriorating relations among the contracting parties, my client towards the end of 2018 initiated arbitration in accordance with the arbitration agreement contained within the agreement. Arbitral tribunal was formed under LCI rules and first hearing was scheduled on 13th of April 2018, which is today. During the period from formation of arbitral tribunal, which is end of the March, up to the first hearing, which is today, my client, which is a claimant, has become aware that of some fact regarding or related to Mr. Frederick Manson, the presiding arbitrator, based on which we wish to record our dissatisfaction with his conduct due to reasons which will be explained further, and would request challenge and revocation of arbitral tribunal under provision of Article 10 of LCI rules. Before I present the grounds on which the arbitral challenge are based against Mr. Frederick Manson and subsequently his revocation is requested, I would like to discuss the procedure matter. I would like to read the clause 46 of the condition of contract 46 titled Dispute Resolution and Arbitration. This contract shall be governed by a Scots law. Any dispute arising out or in connection with this contract, including any questions regarding its existing validity or termination, shall be referred to and finally resolved by arbitration under the LCIR rules, which rules are deemed to be incorporated by reference into this clause. The place of arbitration shall be London. The UK the numbers of arbitrated shall be 3. The language to be used in the arbitral proceeding shall be English. While the arbitration clause shall thus stipulate that the governing law shall be the substantive law of Scotland, it does not specify the Arbitration Act 2010. Accordingly, as the place or seat of arbitration is England, therefore governing statute is Arbitration Act 1996, in addition to the LCIA rules which are applied to this case. I would like to present my case to the tribunal based on the two reasons argument. One is impartiality and independence, another is improper delegation. First, impartiality and independence. In accordance with 1996 Act Section 1A, the object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. Impartiality, therefore, is an indispensable part of the arbitration. Under Section 33(1) of 1996 Arbitration Act, there is a requirement for arbitrators to act fairly and impartially between the parties. I would also like to highlight that the English Commercial Court has recently identified impartiality as what a fair-minded and informed observer, having considered there to be a real possibility that the tribunal was biased. This was based on the case W Limited versus MSDN BIST 2016 EWIC 422 commercial, which was a challenge to set aside an award on the grounds of bias as serious irregularity under Section 68 of Arbitration Act. In order to assist the court in delivering the appropriate determination, I would wish to review the LCI arbitration rules. Article 10.6 regarding impartiality, circumstances that give rise to justifiable doubt. Section 33 describes the duties of arbitral tribunals. Section 33 general duty of tribunal is 1. Act impartially and fairly between the parties. The right to be heard by an independent and impartial tribunal is further reinforced through Article 6.1 of the European Convention on Human Rights, which became part of English law following the passage of Human Rights Act 1998. Upon investigation, my client became aware that Mr. Frederick Manson presented a paper at a conference 2 weeks ago discussing the possible solutions to a nearly identical legal problem to the one between claimant and respondent in this arbitration, and making it clear to the audience that it arose in arbitration where he was currently involved. This speech is a breach of Code of Confidentiality in accordance with Article 5.3 of LCI rules, and also it failed to pass the impartiality test. The relevant rule, as we discussed, impartiality that whether the fair-minded and informed observer having considered the facts would conclude there was a real possibility that the tribunal was fair. This was also established in Potter versus Megill 2002 to AC 357 case. In addition, I would also refer LCIA court case reference number 132498 decision rendered 24 December 2014 wherein arbitrator appointment was challenged. It was decided that bias or impartiality includes when an arbitrator has prejudged an issue by expressing a firm and definitive opinion on it. Similarly, an LCIA reference number 142683 decision rendered 4th August 2016 where an arbitrator divulges that he is sitting as an arbitrator in an ongoing case, the fact that had not been publicly reported, and does not qualify a statement about issues that have not been decided in the case. Circumstances exist which give rise to justifiable doubt as to that arbitrator's independence and impartiality. Hence, the conference wherein Mr. Frederick Manson expressed his views referring to a case which has a striking similarity to ours and proposed resolution, we can say with surety that Mr. Frederick Manson have expressed his views on the merits of the case without contemplating the possibility that his view might change, and by expressing that view prematurely outside the mandate provided for the preliminary issues phase of the arbitration creates an appearance of bias. Based on the above, it is clearly established that the circumstances exist that give rise to justifiable doubt as to an arbitrator impartiality there exists. There is by Mr. Frederick forming an opinion. And if circumstances exist which give rise to justifiable doubt as to their impartiality or independence, parties may challenge the arbitrator. Now we'll go to the improper delegation or the role of a fourth arbitrator, secretary. The WhatsApp message that was received by Mr. Steen, who is the CEO of my client, from Mr. Frederick Manson, in our opinion, is improper delegation of arbitrator duties, wherein the secretary is supposedly asked to act as a fourth arbitrator. Here I would refer you as a fourth arbitrator in our opinion. Here I would refer you similar case ruling heard in LCIA court. LCIA reference number 142683. Decision rendered 4th August 2016, wherein it was decided that tribunal should take care when eliciting views from a tribunal secretary as to the aspect of the arbitration that it is not seeking a contribution to the decision-making process. A decision-making process can be argued. Now we'll go to another question. Similarly, in P versus Q 2017 EWIC, the English Commercial Court had to consider whether a tribunal constituted under the LCA arbitration rules had improperly delegated its duties to the tribunal secretary. The application was made pursuant to Section 24(1)(d) of the Arbitration Act 1996, which gives to the court the power to remove an arbitrator where such arbitrator has refused to fail or properly conduct the case. This has quite similarity to our cases. In this case, the chairman of the three-member tribunal mistakenly sent an email intended for the tribunal secretary to the claimant. In the email, chairman forwarded an email from the claimant and asked the tribunal secretary your reaction to this latest from the chairman. This is exactly similar to our case. The claimant then brought challenges seeking to have all three members of the tribunal removed on the basis, among others, of improper delegation to the secretary. The LCI court heard the challenge and analyzed the time spent by the secretary, chairman, and co-arbitrator on three procedural decisions issued by the tribunal. Now, I want to make a point. Although the challenge was not upheld by the LCI court, however, LCI court has analyzed the time spent by the arbitrator, so they made sure the arbitrator has spent enough time in the judgment procedure, not the secretary. Following the judgment, the LCIA implemented changes to its note for arbitrators in relation to the tribunal secretary. A tribunal wishing to appoint a secretary is now required to outline the task that the secretary will carry out, and the parties must expressly consent to the task proposed. This is not the case. Our client never consent any task related to the review of the documents, which are very fundamental for the commencement of the arbitration. Such tasks as seeking advice from secretary is not consulted by my employer, hence constitute a breach of LCIA rules. I would like to bring to your notice the LCIA notes for arbitrators issued 2017, wherein the arbitrators were advised regarding use of the secretary. Dear counsel, now I will conclude my point. Based on the foregoing, we are of opinion that for such a position of presiding arbitrator, the earlier mentioned cases and their judgments and the LCI court ruling should have been known, and such acts are breach of conduct in accordance with Article 10.2 and 10.3 of LCIA. Hence, we request you to remove Mr. Frederick Manson as presiding arbitrator. Thank you very much.